said, 20 crores.
Was it the amount which has been awarded against you?
It will end the matter.
No, he will not withdraw it. It will be in court.
I understand that. Not
free and speak news.
The arbitrator has recorded a finding that there was breakage and damage to the property at the. He said 2.5. According to me, it is 10. On this dispute, this quibble is going on. I am only suggesting that if I replace the property by another property.
Not another property. You have to put. There's a money decree in his favor.
But our money decree is subject to 34 against.
But today it's a money decree. It has the effect of a decree.
Agreed. But not I.
So you have to make good that decree, and we quite see you should be allowed to exploit the property. Why keep it in his possession?
No, it does.
Because if it's in his possession, he must be also letting it out, or God knows whether they are letting it out or not.
No, I will, my lord, then I'll have to, my lord, repair the property and then see what I have to do.
But you will get your property back against the deposit of that amount, and they will not get the money. If they want to withdraw what you have deposited, they'll have to issue a bank guarantee. Eventually, that will be decided by the High Court. But usually, High Court will tell them, all right, you withdraw against a bank guarantee. But you will get your property, which is worth much more than 20 crores.
Because of the value of this property, I was giving another property, my lord, which is valued much higher than this 20 crore. I would have given property worth 100 crore. I want this property back. I give you another 100 crore.
Including deposit.
That in the event I deposit, I will try to get my property. I don't want another round to start. Unless there will be litigation going on. Can you just make that observation?
No, but then we'll have to hear them, because now your application is dismissed.
No,
we can give you liberty to go back to the High Court with an application that you are willing to deposit.
Your Lordship might say that. So it will expedite it. This actually doesn't suit anybody.
That's much better.
It suits nobody. Neither my client nor me. Your Lordship might just say that.
By the arbitral award, we'll just write a short order. By the arbitral award, the claim of the petitioner was rejected, while the counterclaim was allowed in part or wholly.
No, their counterclaim.
Was allowed.
Their counterclaim.
This shows the award.
Both claims were partly allowed. The Lordship will see that. Volume 3.
Page. One second. We go to the.
UTF is 8.1. What do you see? Page 927 of the volume 3.
927.
Yeah, I'll give you the PDF. 927.
What is the internal page?
927.
All right.
It's below the third last page of the award. Para 102.
In the arbitral proceedings, before the sole arbitrator, the petitioner was the claimant, while the respondent was the petitioner was the claimant. Let's stop. The claim, the dispute between the parties, uske pehle likho. The dispute between the parties arose out of a lease deed in pursuance of which the dispute between the parties arose out of a lease deed in pursuance of which the respondent had paid a security deposit to the petitioner. Full stop. The respondent terminated the contract. The respondent issued a notice of termination and sought a refund of the security deposit. Full stop. The dispute between the parties was referred to arbitration. The arbitrator, the sole arbitrator, by an award dated 1 November 2023, allowed the claim of the petitioner in the amount of rupees 1 crore 50 lakhs 67,568. ये आपको मिलेगा PDF पेज 950 पे.
This will also.
Allowed the claim of the petitioner.
Three claims.
They were allowed 3 claims of the petitioner. I just saw that. Yeah, allowed 3 claims of the petitioner. Full stop. The counterclaim of the respondent was allowed by directing the petitioner to refund to the respondent the lease rent security deposit in the sum of rupees 18 crores 26 lakhs 18,051 and the maintenance security deposit in the amount of rupees 2 crores 41 lakhs 96,564. Page 951 को मिलेगा. And the electricity security deposit. ऐसा कर लीजिए. The counterclaim, we'll just put it in a much shorter way. The counterclaim of the respondent was allowed in the aggregate amount of rupees 21 crores 34 lakhs 14,615 together with interest at 12% per annum from the date of the deposit of the security deposits till actual refund. Where is that written that he can hold on to the property until until the counterclaim is paid?
903.
The arbitrator also directed that the respondent would be entitled to retain possession of the lease premises
PDF 924.
until the counterclaim is paid.
Para 52.
Into brackets, paragraph 52 of the award. Correct?
Para 52. Yes.
Next. Petitions under, one petition under section 34 by you. Only one petition, right? The petitioner has instituted proceedings under section 34 of the Arbitration and Conciliation Act 1996 to challenge the arbitral award. We'll stop. During the pendency of the proceedings, the petitioner moved the High Court for permission to provide security in the form of alternate immovable property in substitution of the premises
In question.
which form the subject matter of the arbitral award. Full stop. During the course of the hearing, full stop, the civil judge in the impugned order recorded that during the course of the hearing, the court had inquired of the counsel for the petitioner. I had indicated, don't say had inquired, had indicated that possession of the lease premises may be recovered by the petitioner upon depositing the amount awarded to the respondent in court, subject to the result of the petition. But stop, this offer was not, the petitioner was not agreeable to this course of action. But stop, hence, the IA was dismissed, bearing in mind the provisions of clauses 7C and 11E of the lease deed.
Well,
Next. During the course of the hearing, we have indicated to Mr. Mukul Rohadgi, Learned Senior Counsel appearing on behalf of the petitioners, Mr. Devdatta Kamath, Learned Senior Counsel, that we are not inclined to interfere with the order of the Learned Single Judge. Stop. We are of the view that the course of action which was indicated in paragraph 11 of the impugned order was eminently the correct one to adopt. Full stop. However, it appears that the petitioner was then not agreeable to depositing the entire amount awarded towards the counterclaim in court. Full stop. At this stage, Mr. Mukul Radgi states that the petitioner may be given liberty to move the High Court so as to indicate that it accepts the course of action which was suggested by the High Court as recorded in paragraph 11 of the impugned judgment and order dated 13 May 2024. Stop. We permit the petitioner to do so and to move an IA or any appropriate proceeding in that regard before the single judge.
Instead of saying that I'll deposit or follow the course, you should only say that I will take appropriate proceedings in the report.
The
Whether they
petition,
do, they don't do, right?
it is right.
So we just correct that part.
Yeah, we clarify that in the event that the petitioner seeks to obtain seeks any relief in the nature of the possession of the leased property,
we may move the High Court from-
it would necessarily have to move the High Court in terms of the course of action which was laid down by the High Court in paragraph 11 of the order.
So the earlier paragraph may go.
We'll just clarify
Yes,
that.
okay.
While editing it,
Grateful.
the petition shall stand disposed of with the above clarification. वो नहीं देंगे पैसा, ऐसा नहीं होगा।